Thank you all for joining us today. The New York State Special Education Task Force is a collaborative group of parents, educators, advocates, and professionals focused on improving special education policies and practices. We provide guidance, training, and resources to ensure students with disabilities receive appropriate educational services and supports for their success. I'm excited to introduce the woman who needs no introduction, Tara Moffett. For the last several years, Tara has kicked off the school year by providing a legal updates training. Thank you, Tara, and I'm going to pass it over to you.
All right. So if you want to just pop to the first slide, I just, a little background on me although some people think I don't need an introduction, I always assume that there must be someone new, so I'll give you a little intro. My name is Tara Moffett. I'm a partner with Gervin and Ferlazzo here in Albany, New York, but I work with approximately 70 different school districts, and we're 7 BOCES in varying capacities. So my background for the past 20 plus years, almost 25, don't pretend, is that I have been doing education law and special education and disabilities law since I graduated law school. So this is kind of like some part of my whole, and it makes the day go round. Special ed is unique, interesting, challenging, and one of the greatest civil rights. So we always like to jump right in. So I'm going to go to the next slide and give you a quick overview of what I'm hoping to cover. And it's just to give you the sort of preset of what we're going to try to get through today, because we've got a lot of meat and potatoes. Procedural safeguards update, we'll cover that. Some Faith Till 22, that's one of the challenges and changes that have come about in the past 2 years due to a court case. I'm going to touch upon the redesign of our graduation measures. It's not final yet, but there's a lot still going on. Just want to make people aware of that. The Dyslexia Dysgraphia Task Force, and we're going to talk about some learning disability guidance resources and the opportunity to provide input. I'm going to review the prohibition on corporal punishment, seclusion, prone restraint, and limited, stressing that limited authorized use of physical restraint and timeout. We will cover disciplinary change of places, also known as a DSIP in the special education lingo. So if by chance I say DSIP, that's what it is, disciplinary change in placement. And then at the end, if we have time, I may cover a bit on the workplace violence prevention law. It may or may not happen. I included some of the questions and answers from a recent guidance document from State Ed. So if I don't get to it, I literally copied and pasted the questions, and you have the link embedded in the materials or the PowerPoint, and hopefully you can get to it. If you have an issue or can't, let us know, and we'll be happy to post that link in the chat. All right, so let's go to the next screen, and we'll jump on in. So every once in a while, every once in a blue moon, the state updates our notice of procedural safeguards. The last time they updated it was back in, I believe it was 2021. And they have updated it again. They've included a number of different changes to reflect a larger focus on mediation, to include some additional guidance that the state has developed regarding specific procedural rights. And originally it was only available in English. That came out in May 2024. It is now available online on the State Education Department website in all of the languages listed at the bottom. This should be provided at least once annually, or for an initial referral and evaluation for a student suspected of having a disability. Upon the filing for due process complaint or mediation request, although typically they send it once, we usually will send it if there was more than one. Hopefully that's not happening, but you want to be aware of that. If there is a disciplinary change of placement, important, and we'll come back to this, make sure that you're also providing a copy of the notice of procedural safeguards when there has been a determination that there's a disciplinary change of placement. And obviously in response to a state ed complaint, you only have to do that once with a state ed complaint, but you will never go wrong with handing out procedural safeguards more often than not. But you can run into issues if you don't have them available. I also recommend that they be posted on the district's website, whether you have a special education link or not, as well as made available in the special education office and possibly at your other district offices or central office. Okay, next slide. I'm going to speak both for on behalf of and related to school district advice as well as parent and advocate advice and guidance, just so that you understand. So that was more so focused in on the education team. But now we're going to talk a little bit more about a more global issue, which is FAPE until age 22. Due to a court case that happened several years ago in Connecticut, the New York State Council for our state education department issued an opinion of council back in, this was at the end of summer last year, that authorized that districts should be providing or may be obligated to provide a FAPE, a free appropriate public education, for students with disabilities who have not received the high school diploma until their 22nd birthday or until age 22. So basically, you're entitled to receive a FAPE if you have not received a high school or local diploma, or elected to exit prior to receiving those, and you remain age and resident and age eligible for school district. Primarily, this will likely apply to students who would be pursuing a skills and achievement credential, or for students who may have had other intervening factors where they have not completed their required credits and are still pursuing that high school diploma. This gives a little bit more time. There are challenges. One of the challenges that comes up is our current state law and regs only, and our funding structure only covers FAPE and instruction and resources till age 21. So if any student stays on beyond age 22, that is at the current stat is being funded fully by the district or the local taxpayers. If the law changes, that will allow the financial funding, and that will certainly make life a little bit easier. The other challenge for maintaining till age 22 is one, candidly and specifically last year, people had anticipated that students were exiting at age 21, and then the guidance came out, and then there was a hustle and a bustle to try to figure out, can we get kids back into that program? Is there another option in order to meet the needs of those who sought to return? Another challenge is, being able to recognize that we are kind of running into a limited supply of programs and placements. And so that new obligation does create a little bit of a backlog. Last, but certainly not least, is the challenges also relate to ensuring we have appropriate transition support services and plans in place. And candidly, many of our other community support agencies, OPWDD, OMH, Access VR, all of these programs, in addition to our other community support providers, have been either overwhelmed or understaffed, and that has created difficulties with ensuring that there is that pre-planned seamless transition. Where that has happened, parents and districts should really consider whether it makes sense for that student to continue until their 22nd birthday. And I'll give you one example. If a student is turning 22 in September or October or November, it may or may not make more sense for them to transition at the end of the graduation year, provided that there is that transition support in place. Otherwise, you're potentially into the challenge of competing with the next year's graduating students, and so if you delay, you're kind of in a different basket of people pursuing service. So that is an obligation. It is one that you are entitled to access if the student has it. It's not a mandate. And it's, I think, an important part for districts, families, students to discuss as to what their plans are. Keep in mind, transition planning and everything should begin in New York for the first IEP in effect when the student turns 15. So for many students, the idea of what their goal and schedule is has already been discussed early on. All right, let's jump to the next slide. And there has been, this is just a broad update, graduation measures and redesign. So this has been a long-standing issue and concern, trying to figure out ways to ensure that our state expectations, our credentials for graduation, and our processes ensure that it is meeting both the needs of our students and also preparing them for independent living, college, careers, employment, and citizenship. And so this has been part of a multi-year review, but specifically the Blue Ribbon Commission, commissioned through the State Education Department, had put together a behemoth report of hundreds of pages to kind of go through and identify what they think needs to be address through holding stakeholder meetings and getting information and feedback, including feedback from families and individuals with disabilities, school districts, etc. There was a large outpouring of goals of trying to make it more meaningful, measurable, and more flexible. So right now, the state is taking all of that input in the commission's report, boiling it down, and they'll be presenting, assuming everything stays on track, a plan for an implementation of the new graduation measures. The plan's implementation plan will be reviewed at the Board of Regents in November. If it is adopted or if there's adoption with changes, et cetera, they will establish the timeline through which it will be rolled out. So this will not affect students right now, but if you are a parent of a younger student, or if you're a school district and you're looking to think of what do we need to be preparing down the line, you may want to take a look at these resources. One is the State Education Blue Ribbon Commission report that's available on the website. And the second is the graduation measures for the New York State Education Department. I sent the PowerPoint with the hyperlinks. If you can't access the hyperlinks in your PDF document, just type in graduation measures on the New York State Education Department website, and it should take you right to that link. All right, let's jump to the next slide. So this is a little bit of it's funny because I thought I was doing this last night and I was putting together like little things, and I was thinking literacy, dyslexia, dysgraphia, and I put the math in the background, which is dyscalculia. But nonetheless, we are aware that there has been some development in goals. So jump to the next slide, and we're going to discuss the Dyslexia and Dysgraphia Task Force. So this was a required committee that came into being as a result of the governor signed into law the Chapter 76, which was basically we want to ensure that there are effective research-based instruction strategies for reading interventions and supports for all students, but particularly students through grades K through 5, and that they directed a task force comprised of stakeholders, educators, community members, and other interested practices such as speech language, your reading specialists, your researchers, colleges, universities, and other education preparation programs and administrators to come together and give us their thoughts on this so that they can boil down and come up with some good strategies and ideas for how to meet the needs of students. So next slide. The task for the task force is to prepare this comprehensive, and I guarantee not a short report, for December 22nd, 2024 Board of Regents review, and that should include their recommendations and findings. It's going to focus in on key areas that are kind of the global areas of concern that have been identified. One is, how are we screening students to assess learning disabilities in the areas of reading and writing? Specifically, there is also the obligation, and we will continue to be monitoring and developing for math as well, but this task force is specific to dyslexia and dysgraphia. And they really are looking to make sure that those screening methods and approaches include research-based, peer-reviewed, and evidence-based methods that are inclusive, and meaning it's going to be able to apply or be utilized for a variety of different learning styles, whether they're visual or auditory or verbal or nonverbal, to make sure that we have contemplated that our screening devices are effective and also, to the extent possible, made with a universal design. They will be reviewing different types of reading interventions and looking at what are effective, best practices, what have been successful programs, where does the research support that, and what other approaches. In 1999, the National Reading Panel put together a book identifying different components of reading that really are essential for the instruction. That book is sort of the backdrop, but there are many years of reading research that we continue to monitor. And as we are refining our approach, we are getting more and more research, more and more guidance as to what works and, frankly, what may not be as effective. We've gone through our whole language and our phonics-based instruction, and we're back to phonics-based instruction. And so we really continue to try to refine and make sure that those interventions that districts and providers are using are effective, and that we also are seeing the benefit and the results of that targeted instruction. Educational supports, obviously, when they identify the types of instruction, the strategies, the programs. They will also make sure that they are, emphasizing it both in terms of targeted instruction for students who may have dyslexia or dysgraphia, but also in terms of effective reading instruction overall, to make sure that our global programs are addressing those needs. And then there may need to be some additional focused programs, particularly for students who have dyslexia, which is difficulty with the reading process, or, I'll cover the elements in 1 second, or dysgraphia, which is the writing process. The goal is also to make sure that we have stakeholder engagement. So there are a number of opportunities for parents, community members, and agencies, individuals, school districts, and other interested parties to contribute. I have that information coming up in a slide. And then ultimately, as I said, they'll be disseminating the guidance into a report that will be reviewed by the Board of Regents in December 2024. And then again, what the implementation timeline will be defined by the recommendation of that task force, if that goes forward as scheduled. So next slide. There's also, so I said that opportunities for participation. This is just a very quick, and I'm not going to go through it. There was the Albany conference already occurred last week, or well, this week on September 16th. However, there are virtual hearings that are scheduled. The next one is September 23rd. If you are interested in participating and providing testimony, whether written or through that virtual, you need to sign in. It's a registration required, and you can participate. There's also an in-person opportunity to participate down in New York City, and you'd have to register. These are all, if you type in dyslexia and dysgraphia task force on the state ed website, it will take you to those links. But if you aren't able to attend but still want to submit your input, you can submit electronic written testimony, which is basically write up what you want the state to be aware of or your thoughts, and make sure it's submitted by October 15th. So we'll jump to the next slide. And just so that you're aware of what other resources are out there, New York State issued, a couple of summary documents and some more comprehensive documents. The students with disabilities resulting from dyslexia, dysgraphia, dyscalculia just sort of highlights what the definitions are, and it's a sort of an understanding about what is and is not a learning disability in the areas of reading, writing, math, spelling. It includes a variety of different challenges or areas of dysfunction, but it excludes other areas where the primary reason for the student's lack of progress has to do with visual, hearing, or motor disabilities, an intellectual disability, emotional disability, or environmental, cultural, or economic disadvantage. But other than that, we would be looking at evidence of the student failing to meet standards over time, notwithstanding having received appropriate targeted systemic research-based intervention, at which point they may identify that this is in fact a student with a learning disability, and that may be dyslexia, dysgraphia, or it could just be a combination of different factors. There's a Q&A, there's a 2-page overview. This, the meeting the needs of students with dysgraphia, dyslexia, and dyscalculia. It's just sort of, if you're not familiar, don't understand the process, just take a look at that. That gives you a very quick overview, but it has a lot of nice information and some short buzzwords to help you understand what the concepts are, what the concerns are, and how it relates to the possibility of students responding to interventions in reading instruction, and for those who aren't, what levels of support or services may be required. Several years ago, the State Education Department also issued a frequently asked questions, or an FAQ, on dyslexia, dysgraphia, dyscalculia, and how to meet the needs of students. And that may be both in general education and through specialized instruction. That document has a lot of questions and answers that may help if you are more interested in the topic and want to dig in. And then there's a newer document from the past 2 years, the identification of students with learning disabilities. It's a flow chart, but it also is phrased in the concept of a multi-tier support system. So districts are supposed to have, research-based instruction and services, and that's part of your general education instruction. Then if students are struggling learners within the general education instruction and curriculum, we provide targeted and supportive measures to assist them with reading and learning and behavior and other areas of challenge. That's what many districts will call the multi-tier support system, or MTSS. Some will call it their RTI, response intervention. Others will call it AIS, or academic intervention services. All of those come together and speak to how we are attempting to target specifically, supplemental instruction within Gen Ed to address learning challenges. If that is showing the student is progressing, then they may, remediate that challenge and then get back in and continue with the Gen Ed curriculum. If they're not responding, then it moves up to a higher level tier. And then if there is still a lack of response despite that progress monitoring and documented intervention, then the student may be referred, with the understanding that proviso, their parents may still initiate a referral to the CSE even if the student has not gone through the RTI process. However, the regulations specifically look to and recommend that districts use pre-referral strategies and other approaches. And candidly, if the question of whether the student has received research-based instruction and intervention has not been broached, it's difficult to rule out some of the other factors, such as, the intellectual disability, visual, hearing, and other motor abilities, emotional disability, which may impact your ability to focus, attend, participate, attention. And then obviously there are a number of other factors. And then last, but certainly not least, there's the RTI pamphlet, which is, again, New York State Education Guidance. It's a summary of RTI, which is response to intervention, which is basically, if you're not working with what we have for Gen Ed, and for everyone, we target and provide supplemental on top of what the Gen Ed students get, and then, may increase. If you're responding, great. If not, we may continue to support you, and ultimately, if that does not resolve, the student may end up referred to special ed for additional support. Next slide.
Tara, we do have a couple of questions on dyslexia. Does this slide continue, or would now be an okay time to ask those?
I am going to do a little bit more, so if you want to bear with me for one more second, we
Of
can
course.
see if the next two questions or the next two slides address it.
Perfect.
Okay, so what everyone is going to ask me immediately is, what is appropriate instruction? Good question. And if that was one of your questions, score B for guessing. So it's basically making sure that, our teachers who are providing that reading instruction and writing instruction are, using effective measures that are based on, the capacity to meet a variety of student learners, because not everyone learns the same way. Even in general education, you have your natural kind of bell curve of abilities, but to make sure that they have provided comprehensive and appropriate instruction. And to be appropriate, you need to have specific elements. And when I said I'll cover what the elements of reading are, here it is. So one is the element of phonemic awareness, and that's, what we call sound symbol correlation. This letter makes this sound, so when you see that and you're trying to pronounce a word, you know that those two pieces go together. Phonics is understanding letter sound connection. So, putting together a couple of letters, what is it? What does that sound make, and does it change? So CH together are different than C and H. So you put it together and it's ch, and therefore you understand some of the, phonics. And obviously when you put together multiple, phonic sounds, that's where you start to build your words. Vocabulary, and obviously that is understanding words and their meaning and being able to derive meaning from what you're reading in order to understand the purpose, function, or what it is that you're reading and what that represents. Some students may have, cognitive challenges where they may be able to decode because they have learned the skill, but don't have the capacity to understand that content. That's where, making sure that we're building their ability to understand the vocabulary, and then ultimately we get to comprehension. So it's not just I'm reading letters, but I understand what those letters and words represent. Fluency is the ability to decode and to read the information, familiar and unfamiliar, using regular or irregular patterns with speed, accuracy, and expression. So being able to understand that when you're reading, if you were reading aloud, you may have called prosody or cadence, where, you may go up at the end of a question, like, does anyone have any questions? So it sort of rises up. or if it's, you know, a declarative statement where there's an exclamation point, you understand that that would be, you know, expressed in a stronger fashion. And then making sure you're reading all the words and you're not guessing. So that, you know, your fluency, accuracy, and that all comes back to making sure that they have the ability to decode and they can do it efficiently. And then the reading comprehension is being able to put it all together. So it's not just spending the time and energy figuring out how to decode. It's also being able to listen to what you're decoding or understand what you're decoding and then derive meaning from it. So if you're hearing or reading a story, when you're done, you can answer questions or understand how to get the answer if you have to go back and review the context. So that's, you know, the components of appropriate instruction, and reading programs and reading instruction should be targeting each of these elements through the course of that program. Next slide. The state education department has, you know, their I call the learning disability checklist, which is not oddly, but ironically, you will not find it if you type in learning disability checklist. You will only find it if you go to the RTI response intervention guidance that was issued October 2010. Appendix B has this 3-page guide that tells you what is required as part of the CSE review to determine if we are going to identify a student as a student with a learning disability. So that is something that should be done in each of those circumstances to make sure that we have gone through the elements. So what do you need to consider? What evidence of progress is there? Did we identify evaluations and educationally relevant findings related to, you know, cognitive performance, attendance, etc. Making sure that we've ruled out other factors that may cause underachievement that are not really related to a learning disability. If you were homeless and therefore, you know, you're not getting enough sleep, you may be traveling, you don't have your materials with you, so your decline in performance may be unrelated, but might appear as if you were struggling. And those are things that we need to rule out. And also considering response to intervention or academic intervention, RTI, AIS, or multi-tier support systems. And then the committee, the CSE, have to certify in writing whether they agree or disagree. Remembering that, you know, if anyone disagrees with the determination of the committee, they need to submit a written statement presenting why they believed opposite, whether I agree or I disagreed. If you agree, you don't have to do anything. Your agreement is noted in that form and in that sign off. If you disagree, you need to submit a report. If, for example, the parent disagreed, they can provide a report. The staff have to, the parents are welcome to, but that's what the regulations have. So that's how we go through both the reading and response to intervention and getting to eligibility determination for learning disability. And that does also include, you know, dyslexia, dysgraphia, dyscalculia, as well as other, you know, challenges related to speech and language and learning processing that may rise to the level of a learning disability. Okay, so did that answer those questions? The one other question I saw is, how long does the state recommend RTI or AIS? That is going to be a district local level determination, but I would say that the progress monitoring should be sufficient to be able to determine, is this effective? You are probably going to need to have a reasonable period of time for benchmarking. For me, I always say, you know, you're going to have a sense of whether or not you're seeing progress and response and improvement over, you know, 3 to 6 months, and that may be sufficient to show improvement, because there's still the instructional component. If there wasn't the instruction, or if they were not effective with the instruction, you need to do that, and then you're measuring it over time. But there is no defined by the state level. However, there is, the district should have their policy that will give some parameters. And again, that's also part of an ongoing dialogue with the parents in the school to make sure that we are addressing the needs of the student, and we are, you know, monitoring the effectiveness. If it's working, then keep doing it. If it's not working, then change something, because doing the same thing and expecting a different result, definition of insanity. All right, next slide.
The one question that we had here, and I think I know the answer, but it says, how can the parent know if their child has one of these conditions if they have never been evaluated for it prior? I believe the answer would be to request an evaluation.
Well, there's different parts to it. First off, you know, if you're wondering if your child has challenges in the areas of reading, writing, spelling, one, you have report cards, there's progress reports, there's teacher reports, there's also in most districts, they will do benchmarking or standardized review and assessment of skills at, beginning, middle, and end of years. There may also be, through the Gen Ed instruction supplements of RTI and AIS, that they're going to be also have more targeted data and information. Yes, there is always the ability to initiate a referral, but I always say, first, before you decide, is there a problem, make sure that we've ruled out all of the other components that have been a factor, which is, did the student get instruction? Have they had regular attendance? Is there any other intervening factor, as opposed to making the presumption of disability if it was a lack of instruction or a lack of access? That's an important thing. The evaluation may be more of a reflection, if you don't have that, of the lack of instruction as opposed to the lack of capacity. And so there is a need to have more than just, well, it's kindergarten day one, let me initiate a referral, because no one, has been taught the reading component. They might have had exposure, their parents or preschools may have addressed it, but typically most everyone is learning how to read between, K1, 2, 3. And then after 4, 5, 6, that's when they're, reading to learn, pulling the information out more comprehensively. So it depends on where they are. And I think it's really part of a larger discussion. Is the student making progress? Are they meeting standards? If not, do we know why? Do we have an explanation? And if not, that may be, despite the interventions, the time to look at a referral. So let's jump to the next one.
Thanks so much.
All right. And I'll try to talk slower. I know I pick up speed when I get enthusiastic, and I'm always enthusiastic about special ed. Okay, so we're going to topically discuss disciplinary change of placement, manifestation, and certain exceptions. Jump right to the next slide. Why this is a big issue is globally, disproportionality in school discipline, and in particular for students with disabilities, more than 2 times as likely to be suspended compared to non-disabled peers. We're only 13.2% of the population of students, but get 20.5% of suspensions and 24.5% of out-of-school suspension. You know who's the most suspended? Preschoolers. Those little kids, man, so obviously there were problems in terms of how those issues are playing out and how students are being impacted. And obviously with suspension and removal, although in many cases there's alternative instruction, it does also impact student overview, performance, and progress. So I'll let you read the rest of the numbers and process that yourself. I'm going to jump to the next slide, where I'm just going to give just very, very short overview. Aside from teacher removal from a student, and I'm not going to jump into that because that's less of, it's usually for a very brief period of time, and that's usually resolved quickly. There are 2 kinds of more formal removals. There's also obviously informal conference and detentions or lunch detentions or other responses or even potentially restorative practices. But when it comes down to a more significant behavioral issue or conduct violation of the school district code of conduct, there's typically after the series of interventions, you may get to what's known as either a short-term or a long-term suspension. Short-term suspension is anything up to 5 days, and it may be issued by a principal, a superintendent, or the Board of Education. It requires notice of the incident, the opportunity to be heard, to question complaining witnesses. That notice should be in writing prior to the impact of the suspension, although there are limited exceptions if the student's continued presence is deemed likely to result in substantial disruption or danger and injury to others. There may be an immediate suspension, but that student should have promptly the right to the informal conference and written notice and all of those other elements. And then they also receive alternative instruction, definitely if they're compulsory education between the ages of 6 and 16. But also many districts will continue to offer alternative instruction, because even though the student is out, our goal is for them to educate. So we don't want to have them miss that instruction. But that is, the standard process, and that applies to every student, disabled or not. Our second option is long-term suspension. And again, this applies to all students. It's a suspension of anything beyond 5 days. So instead of the principal or a letter where there's more of an informal process, a longer term suspension requires a formal process, and that includes the right to an impartial hearing. That's subject to the opportunity for the student to have a continued suspension under the circumstances that the incident warrants that, and that the district is able to establish that the student violated that code of conduct, and therefore additional consequence beyond what was already performed is appropriate. There is a requirement that there be written notice and the opportunity to attend and participate in that hearing. The parent and student may choose to bring representation or counsel to assist them in that representation. And then after they present evidence and witnesses, they can cross-examine evidence and witnesses that the district is presenting. And then the hearing officer or the superintendent will render a written decision. And with that decision, there will always be notice of the right to appeal to the Commissioner of Education or to the Board of Education, depending upon the district's size and practice. During any extended suspension of beyond 5 days, the alternative instruction must be provided for students who are compulsory education age and may be provided for those above, again, based on the same concept. Also applies for students with disabilities who, even though they may be above compulsory education age because of their entitlement to FAPE, a free appropriate public education, they may continue to receive alternative instruction. So let's jump into what's different. Okay, so we have different kinds of, we need to jump to the next slide, please. So we have different kinds of identification and something called a disciplinary change of placement. So up to the first 10 days of suspension or removal in a given year, a student with a disability is basically treated the exact same as a non-disabled student. So they may be subject to 1, 2, 3, 4-day suspensions. They may have a superintendent hearing and may have no more than a 5-day suspension or a 6-day suspension. It's when they cross that 10th day that it triggers certain additional procedural rights for students with disabilities, and that is the right to a manifestation determination. Understanding and determining whether or not there is a disciplinary change of place is a decision that is made by the disciplining authority. Typically, that'll be a principal. It may also be a superintendent here, based on that hearing. It's going to depend on a case-by-case and circumstance. Sometimes kids will have a number of short discipline, and then they're referred to a superintendent's hearing, and it may put them over that 10th day, so the review will be required. Other times, if it's a short-term suspension, you're not going to get to that disciplinary change of placement. But it's basically a removal for 10 consecutive days plus, or a student who's been subject to removal that constitutes a pattern, because it's been more than 10 days collectively for, portion of the year. And if it's similar in nature to prior conduct and behaviors, then they'll look at different elements, the length of time of removal, the amount of time, the circumstances, and, proximity of removal to one another. Those are all part of that review. Next page. There's also a disciplinary change of placement, which may occur as a result of what I call non-discipline. So the sort of unofficial removal, not as a result of a CSE or an IEP recommendation or a behavior support, but sort of the like, hey, it's a tough day, go home. And that's not written up as a suspension. Those are issues that we have to be careful of, unless that is something that is an agreed upon plan that's part of the IEP or a behavior plan, as opposed to just sort of, we'd like a break and that's there. Understand that, we work very hard to try to collaborate with parents. Parents, want to be responsive and may want to bring their child home if they've had a tough day, but it's got to be careful, because those can add to that. And again, it's not a removal if the student is afforded the opportunity to participate in the gen ed curriculum, gets all of their IEP services, and has the same opportunity to participate with non-disabled peers. Some districts have an in-house alt-ed, where the student goes in, they pick up, they're still getting the same curriculum, they still have, peers that they're interacting with. They may go out for related services, they may go out for resource room, but they're still receiving comparable education, as well as, peer engagement. That would not be a disciplinary change in placement, it's a change in location where they're receiving the instruction, but it's not a flat out disciplinary change of placement. If you have students who are placed in ISS and there's a TA there to help them with their work, but there's no primary instruction, they're not getting services, they're not interacting with non-disabled peers, that's going to be potentially part of a disciplinary change of placement countdown. So skip to the next. So what qualifies as what we deem a removal? It's, removal due to discipline, and when they're not in their current education placement. So there's sometimes, a student is out of their education placement because they're going on a walk as part of a break. That's not a disciplinary removal. That's when they're using an identified strategy that we've typically included, that they have opportunities for breaks as part of an IEP. That's not disciplinary removal. But, when a student is going down to the office and, being questioned, they're there for an extended period of time, they're missing instruction, they're missing, services that would potentially qualify as a removal. A change in placement for a student with a disability to an IAES, that's the interim alternative education setting, that can only be ordered by a hearing officer or a superintendent, where the student engages in conduct that involves what I call the 45-day exceptions, which is serious bodily injury, illegal drugs or controlled substances, and use of possession of weapons. Those are what I call the 45-day exception, because even if it's a manifestation, you have up to 45 days that the district may impose discipline, but it's always discretionary, and it should factor in students' relevant information, their age, their ability to understand the impact of the conduct, and also may consider other factors such as what the CSE and parents have come to agreement on. Bus suspension may be part of a removal if it's part of the student's IEP, and if as a result the student is not accessing their education, that may also be part of the disciplinary change of placement removal factors. So who's going to make that determination? The next slide will identify it's going to be the district. It's on a case-by-case basis, and they're going to look at whether or not it constitutes a disciplinary change of placement. If the answer is no, then there's no additional notice requirement. If it is, and or there's a fair likelihood that if you're more than 10 days of discipline in a year, it's probably going to raise the question of, is this a disciplinary change of placement if it involves a student with a disability? This is where they must provide, remember I said the procedural safeguards notice, we'll talk about that later. So you must provide a copy of the notice of procedural safeguards in addition to notice to the parent about the potential for a disciplinary change of placement. And that's when typically that information and notice is included in what we would call a manifestation determination review notice, to advise the parents that we will be meeting as a committee to determine whether or not the conduct that has resulted in or might result in further discipline is a manifestation of your student's disability. That's the process through which we look at and try to identify if the underlying behavior is directly or substantially related to the disability, and therefore should be addressed more through programmatic supports or services, as opposed to a student who may need where it's unrelated. And just kind of, students with disabilities are students first and foremost, and all kids can make bad decisions. And so we look at those two factors, or whether or not the conduct or the violation resulted as a failure to implement the IEP as written. So let's jump to the next page. Who makes that? Sorry. Who makes the determination? It's still, again, the school staff, and typically there's going to be a review. But if you have a student where you potentially see a pattern forming, if there's starting to have some difficulties, there's no reason to wait till we get to a manifestation. That's where we start putting our heads together, parents, district staff, administration, and look at collaboratively and collectively, do we need to do something to prevent this from becoming more of a problem? So if we're seeing similar patterns related to those removals, or if there is if we could address some of that behavior through minor changes. So, we have a district and they have, different, positive behavior intervention supports, but it's delivered over the course of the day, and usually the kids have to earn, and at the end of the day, they'll be determined if they met their criteria. With some students, we may need to give their, reinforcement much more often. So there might be some way to adapt the existing system. If they have an IEP, they also may look at, do we need to make any changes to that? Do we need to add counseling? Do we need to add other supports or other strategies? Do we need to look at environmental factors? Is the student, should they be away from certain areas or near certain areas? And then thinking about if the global classroom, school-wide, or individual teachers' plan for their students and class as a whole is not effective or working for the student, do we need to look at an individualized plan of targeted supports? Functional behavioral assessment will help us identify the function of those types of behaviors, and then provide targeted support and behavior intervention, which will include, teaching alternative strategies and replacement behaviors, reinforcing when the student is using appropriate, conduct, or utilizing those alternative behaviors and reinforced strategies, and trying to make it less likely for them to continue to do that. And that could be by controlling certain triggers or antecedent factors, and then making sure we're not rewarding or reinforcing. There was one year I had a student who was constantly getting sent down to the principal's office, and they were a wonderful principal and so kind and so giving, and they had a popcorn machine in their office. And so when the kids get down, they would, get popcorn, and unfortunately the student really liked popcorn. So they kind of kept using that system to get on down there. And once we realized that, we kind of said, let's not, have popcorn as a reward, and that might help with, coming on down there. And it did after we addressed that. But again, you look at all of those different factors and you try to figure out what we need to do. Next slide. So just a sort of quick overview of what it is or is not a disciplinary change of placement. If it's not, then, the personnel will consult with the teacher. The person who's imposing suspension will consult with the student's teachers and determine what services do they need to participate in the Gen Ed curriculum and to continue to progress towards their IEP goals. And that, is typically going to be, they're going to, get the same minimum number of hours of instruction that would be applicable to a non-disabled student. And so if it's elementary, it's 2 hours a day of alternative instruction. And if they're secondary, that's 3 hours a day minimum. And then they may also need to receive other supports and related services and accommodations or modifications to make sure that they get that, and also look at a functional behavioral assessment and whether or not you need to develop an individualized behavior plan to address that behavior. If it is a disciplinary change of placement, one, the district has to give that notice of potential disciplinary change of placement, procedural safeguards, and notice of a manifestation determination, and then meet and conduct that. And if they identify that it is a manifestation, then the student typically would return, unless it's a 45-day exception. That's the drugs, weapons, and serious bodily injury. And, if they have not already had a behavior intervention plan and they find that it's a manifestation, they're going to need to develop an FBA BIP as appropriate. If they have one, they should review and address or update that. And then more importantly, if it is not a manifestation, the student would be subject to a discipline and removal as they would apply to any non-disabled student, but they also have to have access to a FAPE, although it's in a different setting, and that's where the CSD kind of goes through that similar process and says, what do they need in order to be able to make progress, even though they're not here because they've been removed on a disciplinary basis, to continue to meet the goals in their IEP and have access to the curriculum. And again, we're also looking to make sure that that manifestation determination happens before the student is subject to, a continued out-of-school suspension, because that's a procedural right. So jump to the next slide. I'm going to skip this one because I said, why do we give a copy of the notice of procedural rights? And it's basically for all of the reasons I've just explained. It's about the rights, it's the notice, what it means, how it applies. So this is just sort of a limited summary and 45-day exceptions, and it also includes notice of right to appeal. So we'll skip on by that. So let's go over the manifestation determination process. A manifestation of termination is required each time the student is removed for more than 10 days where it is a disciplinary change of placement. So for the first time in the school year after, if you're coming up on the 11th day of discipline, you need to do a manifestation. That's a requirement, and that should happen before imposing any additional discipline or removal. So it's important to have a system for timing to make sure everyone who needs to know is aware about discipline and the potential impact it may have on students with disabilities, and making sure that they have access to the manifestation and rights, as well as alternative and instruction if need be. The review of the manifestation is basically relevant members of the CSE, as determined by the district and parent, come together and review information in the student's file. That's the IEP, it may be reports, evaluations, it could be your most recent reeval, it could be updated or annual testing, it could be benchmarking, it could be relevant teacher or provider observations, such as, if the student has a communication issue, if the student has, cognitive impairments, a psychologist may be weighing in. And then you also take into consideration relevant information from the parent. They may provide information that was not known at the time that might have, explained where the student is coming from or what circumstances exist, and, what occurred during the incident that resulted in discipline. And they ask two questions. One is, was the behavior directly and substantially related to the disability? Meaning it's, a critical component. It's part of the, the student's behavior. It's part of what we're targeting through the special education programs and services. This is something that we are working on, and it is directly related. Or was it the result of the failure to implement the IEP? And that's really where you look at, did the district implement? Was, if the student had counseling and the counselor has been out on maternity and they don't have a substitute, and so the student is going without that necessary counseling to help them build that, social, emotional, and cognitive flexibility to be able to manage frustrations, that may be a manifestation. It's not, so they look at those qualitative factors and make that determination. If you go to the next slide, the timing on when we do that manifestation is, immediately, or, but not later than 10 school days, because we want to make sure that we have that in a timely manner. Once you cross that 11th day, manifestation needs to happen. And, if it is a disciplinary change of placement, or as a result of a superintendent or hearing officer moving a student to an IAES, which is that interim alternative education setting, based on a finding of 45-day exception, or the hearing officer issuing an order saying that continuing the student in the current placement is likely to result in an injury to self or others, the hearing officer can issue a special order to remove the student as a result of, the dangerousness. Again, district still has to provide alternative instruction and address the student's underlying needs and instruction, but it provides that support. Written notice is required. Again, opportunity to participate, and the 5 days notice. Everyone always says, well, wait, we have to get 5 days business notice. Well, manifestation, there isn't a per se regulation that says it must be delivered within 5 days. You want to make sure that everyone is aware and has the opportunity to attend and participate, but this is a regulatory requirement, and it's triggered based on something that you can't necessarily know or control the timing on. You don't know when a student is going to get a 4 or 5 day suspension that's going to cross over. So the timing of manifestation may need to be intentionally relatively quick, but you need to make sure that the parents have had the opportunity to come and participate. They've received notice. And I always say, when you're sending out the suspension notice, you want to try to get to the point that the suspension and the CSE manifestation notices go out simultaneously, so that they have the same notice of, the informal conference and possibly the manifestation, or with the hearing notice goes out, to try to make sure everyone is aware, because you want to have that discussion, and it's going to be necessary and timely. One question everyone says is, when do you have the manifestation? If you're at a principal suspension, it's going to be prior to the imposition or continuation of the discipline that crosses the 10th day. If they're going to a superintendent's hearing, it's going to be after there's a finding of guilt or an admission of guilt on one or more of the charges, because then you need to determine if that conduct which they have been found guilty of is a manifestation. So sometimes in the past, people used to do manifestation first, and so I didn't schedule a hearing if we didn't need to. But if there's no agreement that the student engaged in the misconduct, they should do the guilt phase hearing and make that determination. And then if they find that it is a violation of the code of conduct, manifestation will then determine whether or not they're going to resume for a penalty phase. And that's where they may impose additional discipline without, they wait to find out if the CSE is going to impose discipline, or they'll issue a determination with the understanding that it is subject to the CSE's manifestation determination, meaning that if the student engages in the misconduct, but the CSE finds it's a manifestation other than 45-day exceptions, in that case, typically that's the end of discipline. Where it is a 45-day exception, even though it's a manifestation, if that's been the committee's determination, that student may still be subject to removal, but they're still going to have access to a phase. Okay, next slide.
Carol, I have one question, if that's all right. I think you might have answered it just then, but it says, must the manifestation meeting happen on every suspension past the 10th day, or only if there is a DICP or pattern found?
It's going to be when there's a disciplinary change of placement, but I will say that it's going to be challenging to not find a suspension or removal after they've already got to 10 days. Is going to be completely separate and unrelated, that it wouldn't trigger a DSIP. So I'm going to say, as much as it's probably going to be that you're going to have more manifestations if there is, extended discipline. And I'm going to talk about what we should be doing instead of discipline if we have that option, but we'll come back to that. So the purpose of the manifestation determination review is to basically make sure that the student's not being removed because of conduct that's directly related to their disability. Again, there's always the possibility that the committee may not come to consensus, and ultimately the buck stops with the district and the chair. They have to make a determination, and parents will receive notice of the determination, and that is something that they can appeal, or if they disagree with the IAES, the interim alternative education setting, parents also have the right to appeal that. If they're, that's part of those procedural rights. And the people who are part of that manifestation team, as I said, it's relevant members of the CSE, and that may be anyone who has knowledge and understands the behavior, the underlying incident, or relevant factors about the student's disability, and obviously the parent. And it may be, we may bring in people who would not typically be part of that, maybe a building administrator because they were there and investigated the incident. It may also involve, sometimes parents will have an outside provider or a community agency rep join them for that, to weigh in or share about some community support. All of that is based on, the district must have the relevant members. The parents may also ask to invite or include others. So let's jump to the next slide. I already covered what this is, and so I'm going to skip that. Somehow I had a duplicate. Sorry about that. And then the slide after that is, again, what happens. If you find manifestation, typically the discipline is ended. Now, want to be clear that would be the typical response, but parents and districts sometimes can say, this may be a manifestation, but we also don't agree that this program is working, and we may want to look at something different. So they can agree to a change in placement or other strategies, even though it might have been that the child was eligible to return. Parents and districts can always agree otherwise, and there's a questions and answers document about discipline and IDEA that was issued in July 2022. It's a PDF, and I cite to specific questions. So when you see F4 and F5 down there, not talking about planes, these are actually questions on that particular document. And then always you're going to find that if it is a manifestation, you're going to review, conduct, or update an FBA BIP to address that underlying behavior to hopefully prevent that from occurring. If it's not a manifestation, as I said, the student would be subject to discipline the same as any other non-disabled student, and they would receive, a 2 or 3 hours of alternative instruction, because that's the state mandate that was finalized and updated, and that's part of what's in the updated procedural safeguards, went into effect a little over a year and change ago. But it also requires that if they are a manifestation and it is beyond 10 days, which if you're doing a manifestation has to be a disciplinary change of placement, then they're also entitled to receive access to a FAPE, and that is alternative instruction of, 2 hours for elementary, 3 hours for secondary, plus whatever else the CSE determines is necessary to give that student the opportunity to make progress towards their IEP goals, although in a different setting, and to access the curriculum. Sometimes because the student may need additional breaks or more processing time, they may need to look at, do we need to adjust the amount of time or the duration of instruction? Other times it's, do we need to look at adjusting aspects of our related services if they're not able to come on campus? Do we need to look at virtual? Do we need to have them in individual versus a group for this period of time? You need to review that and address those issues so that there's a plan so that the student can continue to make progress towards their goals. And what the alternative instruction looks like is going to be different for each student, particularly students with disabilities, because yes, there's the tutorial instruction and it should be addressing the students' core content areas and subjects, but it also may, require additional information or resources such as the related service providers, counseling, other consultation and supports. It may be that the student is coming and bust in and they're receiving those at school. They may be getting at a different location. There's a number of different factors that go into that decision. And that's part of that CSE discussion about what happens if there is any additional discipline that's imposed. And it minimally has to meet the 2 or 3 hours that you would give to any student who's removed. But it then would also include anything extra that's required. And then the question I saw, one of the questions I saw was, is the 2 hours separate or could it be inclusive of the related services? That's going to really depend upon the situation and the student. Typically, it would be the 2 hours plus those related services. But again, there may be other factors, medical, health, other, where, that may be medically, if you have a student in crisis who's engaging in, extreme behaviors, they may not be able to withstand the total number of services, or they may be participating in an outpatient, partial hospitalization program where in order to accommodate, we may agree with the parent and do a reduced number of hours. Otherwise, it minimally should be the 2 or 3 hours. And then on top of that, whatever other supports or services that are recommended. So let's jump to the next slide. And this is basically just sort of the summation of both. Yes, it's a manifestation. No, it's not. And a very quick, abbreviated review of what's supposed to happen. And end of day with both, we still want to make sure that we're reviewing and updating an SBA or a BIP, or getting one if we don't have one when we find that it's a manifestation. So let's jump to the next slide. One of the things I had talked about was the 45-day exceptions, the disciplinary removal to an IAS, and that is that alternative education setting where they have access to a FAPE, although it's not their typical placement. And that's when you have a student who is engaged in serious bodily injury, weapons, possession or use of, or illegal drugs and controlled substances, possession, use, sale of them at school grounds. If it is a manifestation, they're limited to up to a 45-day removal, because even though we found it is a manifestation, this is one of those elements that can be so dangerous or disruptive or unsafe that even under those circumstances, there is a consequence. And typically during that time frame, we're also trying to address the underlying issue that resulted in the student causing the serious bodily injury, weapons, drugs, or the controlled substances. Having meet the criteria for serious bodily injury is a relatively high one, because they borrow the definition of what constitutes serious bodily injury from criminal law. So it's along the lines of permanent loss of use of limb or organ, permanent disfigurement, severe and protracted pain, and so under that or death. But if there's death caused, then we won't be dealing with the situation. But in most of those situations, it's not going to cover the typical pushing or bumping into someone in the hall type stuff. It's really where there's significant injury, and we do have some instances where there has been serious bodily injury, concussions, fractures, broken bones, difficult circumstances, difficult situations where that removal is an important component for both safety, and also to try to figure out what we can do to have a different support level or outcome because obviously we want everyone to be safe. And if it's not a manifestation, if they have the 45-day circumstance, but it is not a manifestation, then that student may be subject to the same removal duration that would apply to a non-disabled student. And, for example, with weapons, that could be up to a calendar school year. There's discretion, but up to. Although I will strongly recommend that discipline and long-term removal are, challenging, because when you have a student who is no longer accessing their alternative education or instruction, it impacts their ability to make progress. And so it's kind of the less they're here, the more they may, fall behind. And that may have its own, circular effect. The other part is, candidly, schools often are providing the majority of services to students, particularly students with disabilities, in the form of counseling and speech and related services. And so, although they will still receive them, that, may be another factor. And the longer they are, there are oftentimes some challenges, particularly now, as we have a very limited number of, providers, particularly related services, and lots of flexibility challenges. So if they're out, they may not be able to access those services, and the district still owes them. But, if the student is not receiving them, although there may be an offer of comp ed, that could actually, increase the challenge for that student. So I would always say, while there is the capacity to impose discipline, it is important to always review to determine, what are we doing with the discipline, and is it, are we being responsive to the circumstance, or is it punitive instead of, looking to remediate, and hopefully bring the student back? Discussion for another day, but just keep that in mind. Okay, next slide is, as I had mentioned, there is also the option of a expedited hearing request from a district for student removal to an IAES, and that's where they have identified that maintaining the student in their current placement is substantially likely to result in injury to that student or others. This is, where we have had, and, it may be that the student has had a series of disciplinary incidents. They may have had multiple manifestations, and the situation continues to present serious likelihood of risk of harm to them or others. And it's a high standard, but there are instances where the student may be ordered out of that program into an alternative setting that continues to meet their academic and educational needs, where if they were to maintain them, there's a very strong likelihood of injury to self or others. You still have to do a manifestation determination, but the hearing officer can order that student out of that original program for up to 45 days, and then there may be a renewal in 30-day increments thereafter if the circumstances and the conditions still continue. Often in those circumstances where there's a lot of communication and hopefully collaboration between the parents and the district to try to figure out what else can be done, because no one wants there to be an unsafe environment, and also no one wants students not to be part of a more traditional program. And so that may be where we're looking at different programming or different services or alternative placement, and or working with other community agencies to try to give us a more holistic and wraparound approach. Next slide. So where are all of these helpful things that I've talked about? Here they are. Each of these is the title of the relevant document. So if you type that in, you'll find them on the State Education Department website. There's updated guidance about avoiding discriminatory use of discipline, and it really talks about, the same issues that I hinted at the beginning as to why discipline and, is a concern, and why we're reviewing it so carefully and scrupulously. It's because it disproportionately impacts kids with disabilities. And if they're not here, if they're out of school, they're missing opportunities. And so we want to make sure that, they're not being cited or removed more than their proportionate share. But, better yet, our goal is always to keep kids in school. So we work to try to address those issues more globally. There is updated guidance from the State Education Department, including new forms and tools. A manifestation determination review policy brief that was issued. It says it was June 2024, but I didn't find it until it was online in July, but I'll acknowledge their date on it is June 2024. That's just sort of a written overview similar to what I've just covered. There's a manifestation determination review flowchart. Now that's kind of the checklist that helps you go through and determine what happens and is this a manifestation, and if it's not, what happens, if it is, what happens. There's also a word checklist that you can use and fill in that will help you go through that process. And then there is a updated guide on behavioral supports and interventions in school, which also relates to the topic I'm going to cover next. That includes frequently asked questions related to discipline and removal, including behavior support interventions, what are permitted and what are not permitted in terms of those behavior supports, like seclusion is not, prone restraint is not. There's limited authorized use of physical intervention or timeout, and it walks through many of those and also some common scenarios. And then I'm drawing your attention to the Workplace Violence Prevention Program, which is a long-standing law, but over the last year, it has been applied in a new context to both school districts and BOCES and private approved schools, which has changed some of the dynamics about, addressing safety and work issues and students with disabilities. But ultimately, that guide makes it very clear that students with disabilities have, nothing in this provision or nothing in this act will prevent the student from disability having the same rights and entitlements to access to free, appropriate public education. But for our violence prevention, we may need to do additional strategies, but nothing is going to get to a point where a district can say, no, the student can never be here, and we don't have any obligation to educate them. It may be a hearing officer removal through an IAEF expedited removal process. It could be through discipline, but we do still need to programmatically address that underlying issue. So I want to jump into our next topic, which is prohibition on corporal punishment and limited permitted use of physical restraint and timeout. And I'm going to walk you through that quickly. So jump to the next slide. 19.5, which is Commissioner's Regulations, covers, our prohibitions. So there used to be an individual exception where the state, through its Human Rights Committee, and your district through your Human Rights Committee, could approve the use of aversive interventions on a limited basis. But aversive interventions are things that cause pain or inducing discomfort, and as a means of reducing student behavior. It's relatively rare that such interventions would be something that we want to use. And so over time, with stories and information, like, places where they were using a GED device to do a little shock to people, that was a no-go. Those are the kinds of situations that they came to the conclusion that continuing to use aversive interventions, and that's, one, not the only one, was not really conducive, nor did it produce the desired results, because it wasn't necessarily changing the behavior. So that is now officially gone from our 200.22 regulations. Corporal punishment is a no-go. And so corporal punishment is, that physical contact for pretty much anything other than that limited permitted use of physical intervention, which I'm going to go through more specifically as to what is. Seclusion, which is different from timeout, is when a student is in a confined space and they cannot leave. And it's basically, they're being kept someplace, and that's not for purposes of helping them regroup, recoup. It doesn't meet the definitions of a timeout space, and it's not being used for that function. The only exception is if it is within the parameters of timeout, but there's also a requirement that there's monitoring, that there are, space and distance and light and other environmental factors. So I would say, for the most part, no seclusion, no adverse interventions, no prone restraint, and no corporal punishment. So going to the next slide, we also do not allow mechanical restraint. Now, again, mechanical restraint is when you are utilizing some sort of device or tool to limit or prevent movement and the range of movement. But there are exceptions, like if a student is wearing a helmet for, because they're seizures and they might, be accident prone or could fall, that's using it for the appropriate purpose and not as a, you're behaving badly, you wear the cone of shame. That's not the way it works. Prone restraint has been, systemically identified as a very dangerous form of restraint, and it is now expressly prohibited. So that should not be happening, and all of the training programs and interventions where that might have been an option should be very clear, and the district should be very clear with all staff that face down restraints are never appropriate and should not be utilized. Physical restraint is also not something that should be on an IEP or a BIP or other support plan. Sometimes in the past, there have been, because of different programs, like TCI, where they require an ICMP, an intensive crisis management plan. That's a term we basically borrowed from mental health and OPWDD, but that ICMP is not the behavior plan. That is something separate and apart. What your behavior plan or your behavior intervention plan can identify what support strategies and interventions and replacement behaviors you're working on, and what consequences you're addressing or trying to prevent. But you don't list physical restraint, because that's not our planned intervention. That's our crisis response to immediate threat to health and safety. That's not a behavioral strategy. And we are also added that physical restraint, when the sole purpose is to prevent destruction of property, is now no longer permitted. It's one thing if a student is picking up a keyboard and is about to use it to smash into someone, a physical restraint may be appropriate, even though it does relate to property. But a student who's ripping up their papers or knocking books to the floor, so long as it's not creating, a safety issue where they're, likely to fall on others, you may have cleared the room, etc. We would not physically intervene, but it doesn't mean that we would not potentially continue to use all of the other strategies that are available. So let's go to the next slide and cover what are the limited authorized uses. So physical restraint is, some form of immobilization to move arms, legs, hands, body, limited to prevent that. But there are things that are not physical restraint that are part of what we do, which may include things like a physical escort, not carrying and picking up the student, but I mean physically walking with them, or a brief contact that may be along the lines of, comforting a student who's upset or crying, or, if a student wants to hold your hand, that's not a physical restraint. That's, if you have a little kid who's grabbing your hand in the hallway, that is just part of what we would call a brief physical contact. And sometimes if you're walking down the hall, if you, had your hand on the student and just kind of, they're about to turn to no this way, and tap them and point in the right direction, that's not a physical restraint. But where there is limited mobility, that is where it's a restraint, and it requires that there is written documentation. You only can use a physical restraint when other less restrictive and intrusive interventions, or your de-escalation, your calming strategies, your targeted interventions, using specific languages, scripting with the student, offering them, choices, trying to get them to, utilize a different strategy or different wording or different phrasing in order to regroup. If they are not effective, or we have such an imminent danger that you don't have the ability to do those others, because if you do not, physically intervene, that student is about to, jump off, a bookcase, that may be where that physical restraint may happen as a matter of a necessity, but it is also something that you need to document. And restraint may not be used with preschool programs that are licensed with New York State OCFS. Again, most of the time, our physical restraint, should be that worst case scenario emergency response, because as always, what I say to, my little nephew, use your words. You don't want to grab. If you want to get something, we try to help them figure out how to express, request, point to, get it through some other way without having to, engage in physical, intervention. So next slide is, it cannot be a planned intervention. So if you are districts where it says on the IEP or BIP, physical, restraint as needed, that's not supposed to be there. And, there's clear guidance from the state. So as you're going through for, CSE meetings or updates, or even looking at non-meeting, amendments and discussions, that may be something you need to review. Again, ICMP is different. It is not the FBA or BIP. It may be a supplement, but the actual behavior intervention plan cannot include that. I know some programs still say, well, we have to do it because it's part of the program. That's fine, but understand the behavior intervention, which is what our state requires, does not allow that to be written there. You can use time out, can be part of the behavior intervention strategy and response, but not physical restraint. And there's also a limitation where there is a known medical contraindication that you cannot use restraint on certain students. And again, these are ones where we would probably be well aware of, and hopefully that would not be a situation that we would really have many circumstances where physical restraint was necessary with a student who may have medically fragile circumstances or other issues that where if a restraint became emergent and necessary would need to be used, we need to make sure that there's training and notice so that we avoid that. In those cases, that often is a student that you have to work very carefully with to ensure that they do not get to a level where they're escalating to that point, and that may be, programmatically addressed, and that is definitely going to take, collaboration and support with home and school. I'm going to come up on the restraint and the reporting requirements, so bear with us for a second. So next slide is the limited authorized use of timeout. So timeout is a form of brief seclusion, but there are elements to it. It is monitored. It is in a non-locked setting. There has to be adequate space, light, ventilation. It's for a purpose that you go into, a timeout space or location or area in order for the student to, take a pause, take a beat, regain control. And then the expectation is they're going to come back into their program. We need to monitor the time, the duration, the amount of time they're in. Are they able to regroup and return? What are they doing while they're in there? And they have to be constantly supervised. It can only be used when there's, immediate concern for the physical safety of the student and others, and we may remove them to avoid having, to get to the level where they may need to do physical intervention, or when it's consistent with the student's IEP and behavior plan, and that may be that this is, part of our teaching of reinforcement of alternative behaviors. If you're very upset, let's take a walk, let's step away and go here, regroup, talk to someone, work through, and then you may be able to return. But first is obviously taking that student from here and get them back down to a point where you are back to an instructional control so you can help them work through the problem, because trying to, say to a child, calm down, pretty much has the exact opposite effect in my experience. Same thing, if my boyfriend tells me to calm down, I'm like, that is so not the right thing to say. Okay, next slide. So timeout is not, a student initiated or requested break. If we've taught students particular strategies or coping skills that they're, using their fidget, they're going to get a glass of water. This is something that we've taught them as, a way to, keep them centered and calm, and they kind of are zoning out, but they step out of the classroom, but they're coming back, and it's part of our strategy. That's not timeout. That's them using a strategy which you've identified is more effective than having the student have to leave for, a potentially longer period of time and get support, because they're able to do that regulation. They just need the time or the flexibility. Or if they're using a room or space with coping skills. So, some kids, as part of their behavior supports, may have access to a sensory room where they need to get more sensory input, or they go and they hop into, a swing, and they go in and they've got, a quiet, calm space where they can, relax and use some sensory items, or where they're, receiving counseling as a support. Those are services or strategies, not just plain out removal and then wait for the student to regroup. There's a purpose for what they're doing. And then use of other interventions or strategies. So they're taking a walk and they're talking about the circumstance. They may be, going to get a glass of water. They may be coloring for 5 minutes, and that's part of their, reward or recognition. When you finish, you can color, and now they're coloring. And so others may still be working, but this is part of our plan and strategy. That's not timeout. That's just, working with the student, and it's adapting to their individual needs. It also is not, a teacher removal or in-school suspension or anything else that goes within the Education Law 3214, and that's our discipline and suspension law that I kind of covered earlier. And also, those other discipline actions and removals related to part 201, but there's some reference to 200, rights and hearing requests that relate to the disciplinary actions, and that also triggers manifestation on all of those things. So we're clear on that. So let's jump to new requirements. So
Tara, I just want to let you know we're at 11:30, so we got about 30 minutes left to go. Just wanted to give you a heads up.
All right. So every district now has to have written policy regarding behavior intervention. You should have it posted on your website. It should be available in your, offices and, available upon request. Go to the next page, and that tells you what actually needs to be in that plan and policy. And those are the specific elements. I'm not going to go through each one because I gave you where you can find it and what the links are. But it's just basically, the factors that are going to happen. What do you do? What are your appropriate time restraints for, use of those items? Is it working? Because we're not looking for a child to be in a physical restraint for hours. We're hoping that it's going to be brief and that we're regrouping. No locked rooms, no prone restraint, and there's a lot of training required. One is that, if you're using timeout, it should be part of your behavior plan. If you're using physical intervention, it should not. That there's staff training for both all staff about the policies and procedures, and then there's specific training for staff who may be called upon to intervene. There's also requirements for same-day notice to parents about the use of timeout or physical restraint, which that came into effect, a year ago. And now, in addition, there's also the requirement that the parents receive a copy of that intervention, that restraint or timeout use within 3 business days. And then there's also requirements for data collection, and I'll talk a little bit about debriefing, which is a new element where after the incident, the building administrator or their designee is going to meet with the team that performed the intervention or timeout, and they're going to review, the circumstances and also make sure that they are monitoring if this is becoming, if there's frequent or excessive use, or if it's, if it's being utilized appropriately and well, or if they need to, redeploy or revisit issues and resources. The state is going to be tracking this information more and more, and they have a whole new scheme and requirements for reporting that are going into effect this year. If you go to the next page, first off, all of the districts, all of them, every single one, must do training with staff on policies and procedures for timeout and physical restraint. And that includes understanding and review of evidence-based proactive strategies, preventive things that can help us de-escalate, help us, resolve and work effectively with our students. Those are things like classroom management techniques and, understanding flexibility and all of those components. But you also have to have, every district, a system-wide plan for all students with interventions and practices. So you have your building level supports and strategies, and then you have, what happens if we need to use the physical intervention or timeout. And again, could you have a physical intervention or could you have a timeout that does not involve a student with a disability? Yes, but if that continues to happen, that, and all the notice of requirements still apply, but if that continues to happen, that may trigger the need to look at, do we need to look at, other supports or be, multi-tier supports, or is this warranting a behavior intervention plan? Or do we need to have, a more substantive discussion about the program support or service for that student? For those who will be called upon to implement and oversee or actually apply the physical restraint or the use of timeout, they get additional training above and beyond. That's about the safe, effective, and developmentally appropriate procedures. And those are, doing it safely, making sure that it's likely to have minimal risk of injury to them and to the student. And then again, I always say, whenever I hear the word restraint, I think catch and release. Our goal is not to hold you for forever. It's to, hold the student temporarily or manage them until we can remove whatever the immediate threat to health and safety is. If there's too many items, if there's people that we need to remove, that's what you do. And then, once that threat is no longer there, you may, release the student. And obviously, we're still going to work them through the crisis and hopefully bring them back down. And so there needs to be training on all of those that are specific and beyond just the overview of let's talk about how we can talk to and work with students. Next
Sarah,
slide. Yep.
Sorry, not to jump in, but I think this is a good timely question. It says, if there is a BIP that has a section labeled emergency procedures, can this include discussion of physical intervention that is allowed?
That would be one of the things that the state is saying no to. If that's why I say that in order to comply with your TCI and your CPI and some of those other programs, you may need to have an ICMP to, to comply with their program. But our behavior intervention plan is about behaviors, intervention, replacement behaviors, strategies, and instructional supports, and consequences, and data and progress monitoring. Those are the intentional things that we're doing. Those are our strategies to respond and adjust that behavior. Physical intervention is not going to change the student's behavior. It's a crisis response to the student's lack of safety and an immediate threat. So that's not a targeted intervention. That's an emergency response. So it shouldn't be. And if you do have it, as I said, we're going forward, these are the things that you should be revisiting, and they should not be part of that. And that goes right to the questions and answers from the State Education Department from April. It's on the list of resources for discipline and discipline, manifestation, and restraint slide. That one from April 2024 has specific questions about that, and that there should not be physical restraint listed there. And I know sometimes that was sort of, people would be like, well, and if the student is unsafe, we will use X, Y, and Z. Take that off. It doesn't mean that that is not still what may happen. Physical restraint may still occur as an emergency safety response, but that is not a targeted, intended plan. That is managing an emergency. These are our targeted plans as part of our actual behavior intervention. Okay, so I mentioned the same day notification, and then I mentioned that there's documentation. This long list of everything under the sun is what is required for each incident of use of timeout and physical restraint. I'm not going to cover it, but let's just say it's a lot. It wants, we need to know whether they had an IEP or a 504. Do they have strategies that were implemented consistent with the BIP, whether or a building support plan, or even a functional behavioral plan, or other emergency crisis plans. But if they've got injuries, was that identified? Was that marked? Notification of parent. Also, there needs to be that debriefing that I talked about, and that's the staff and the administrator, and still the notice of the parents, and then opportunities, as well as providing a copy of that report. And then ultimately an ongoing review will happen at the district level to determine whether or not we need to address or respond via training or staffing or reorganization or other approaches or student needs if we're seeing an increase or a rise or excessive use of either timeout or physical restraint, to make sure that it's being used as necessary and appropriate, and not on a effective, in place of effective behavior interventions and support. So next page is just reminding us of the review process, that the administrator or their designee should be regularly reviewing all of these reports and helping to use that to inform their professional development or other strategies. And then there's also, if you go to the next slide, new reporting requirements. Thank you. I know there's some folks from the state, Ed, but at least it's clear what we'll be reporting. And this is where I'm sort of highlighting each event. So if you have a student who is physically restrained, and then they go to timeout and calm down, and then they go back to class, and then there's another emergency and a physical restraint, you are now writing up 3 incidents. First, physical restraint, timeout use, second, physical incident. And the parents need to be notified of each of those, and you need to also make sure that you are recording the duration, that we include relevant factors. There's only 2 kinds of approved or authorized under limited circumstances of these, interventions. And so if it's timeout with or without a BIP, or physical restraint under the circumstances I explained, that's going to be authorized. Anything else, the aversive use of corporal punishment, mechanical restraint, prone restraint, seclusion, those are all going to be counted as unauthorized and improper use of those approaches. And if that's the case, that's going to be part of the state monitoring. They'll be looking to see, that, which is why it's all the more important that districts are doing that ongoing review. And also we're looking from a programmatic training and intervention perspective to make sure that the staff have had the necessary training, are aware of what to do, and that we have taught robust strategies, and that's, both through the behavior plan and others that we're targeting on teaching replacement instruction, that we are utilizing our effective measures, that we are controlling what you can in terms of antecedent, where the student is, who they're near, what kind of demands, what's the pace of instruction, what's the pace of demands being placed on them, in order to try to help keep them in a calmer, safer space so that we don't get to the point where that crisis intervention, as well as the description of the incident. I'll draw your attention to the duration of intervention, is that, they have these categories broken down. So less than 5 minutes, 6 to 10 minutes, 11 to 20 minutes, 21 to 60, or 60 or more. Those are the categories. If you have incidents where you had or seen, which, sometimes that maybe they had the child for, 2 hours, this is problematic. That's not, they're really looking at this as being something that is a relatively short in duration and hopefully effective, crisis response. And that if that is, constantly happening, one, the student is not receiving instruction, which is problematic. And two, it's, going to come to the level of, are we doing what we need to? Is the behavior and support and effective? Is the strategies and resources there? Is the program and placement appropriate? Sometimes the, constant lack of safety in those issues may be the need to have a discussion about programmatic supports, but that also has to be, based on evidence that the student has received the appropriate interventions and supports, and notwithstanding that, they are still struggling. So next page, and this is really what I think is the takeaway, is that really both the Federal Department of Education and the state are really encouraging and supporting the goal of restorative and proactive responses as opposed to reactive discipline. We're looking at de-escalation is our goal. Let's manage and help students, to inform them to demonstrate social emotional learning and control, to be able to self-regulate, and to be able to utilize strategies or replacement strategies. Instead of continuing to have an explosion, we need them to communicate. If they need time, we give them more processing time. We need to work on those and reinforce. And then again, having a good, holistic, supportive, and safe environment, positive, proactive, evidence-based strategies. That can be your, TCI, that can be your positive behavior intervention, your school-wide programs, your class-wide programs. And then there may also be individual behavior plans for specific students. And then that debriefing after the incident, when the dust is cleared, going through and reviewing and making sure that those decisions were done. That debriefing may be the time where they're putting together the written summary and plan. I would say it's important to remember that this document is going to be potentially, reviewed by the state, and it's also going to be something shared with the parent. So I always say to, the staff and administration completing it, take a moment, think what you need to include, and please, please, please write factual. Don't make a, projective report, the student intended to, unless, you can say that the student told me he was going to hit me and then hit me. That's fine. But don't say, I knew he was going to do it because he had a smirk. Let's just focus in on the facts and not the intent. What we're looking at is, was this proper? Was it done with the along the lines of the authorized provision? And was it safe? Was it effective? Is going to be a longer standing discussion. And, that's going to be where they may review the effectiveness or the level of support or appropriateness of the program. Parents are going to get the report. So again, I think it's important to be, mindful to please write exactly what did happen and try to keep it factual, try to keep it relevant. And the important part is also not just the restraint, but what did you do before, what happened leading up to it? Because that's also part that may help us with reviewing whether we need to update, change, or revise functional behavioral assessments or interventions. Okay, next slide is training. Don't use restraint as a intervention. It's a crisis response. It's not on an IEP and a BIP. And reminder that every school has to have this school-wide system for interventions and practices and policies to proactively support. So good, positive climate, multi-tier support system, robust building level interventions and other supports on top of the general education curriculum, our requirements for social emotional learning. All of these components are really, helping us try to form a positive network of support. And that in and of itself helps with managing student behavior. And that also, creates that community goal of that appropriate behavior. And that can help with both, effective student engagement as well as, pre-referral strategies to help us determine whether or not we need to work with that. Next, the reporting. This is just basically giving you, the next slide is just the link to the new reporting memo and guidance. And it kind of covers the same things, what you need to write up. I'm going to skip that because I basically covered it on an earlier slide. What do we need to do for, our updated procedures? Training, same-day notification to parents, additional training for staff who will be implementing, making sure that you have a comprehensive district-wide plans in addition to, potentially the supports that may be on an individual basis. And I did want to draw your attention to guidance from the state, specifically about the need to have arrangements and agreements with school safety officers or other security personnel, because when they're at school, if they're working in that capacity, they're still subject to the state regulations regarding physical interventions and other, other proper behavioral supports. It does not mean that, if the student is being arrested or removed, that they switch back into police mode. But when they're there, it's the administrator and the school that deals with the discipline, not, the security, police, or others. And it really has a lot to do with, handcuffing and some of the other problematic issues. If you go to the questions and answers on behavior interventions and supports from April 2024, it's one of the links on the slide. They have specific questions about the school resource officer and school security officers. And this is an important step that if you're a district, is something you need to be reviewing with and making sure that those agreements or MOU, which is a memorandum of agreement, are included. And as parents, it's just part of our goal. We do have school and safety officers and security personnel to be there as a support and a resource. We also, because it can, we have some school safety officers and security personnel who are wonderful with kids and have great rapport. And, sometimes just they're coming in, the student will, regroup just immediately because they have respect and have rapport. There are other instances where, they've taken over and there's a big difference between how we deal with adults or people outside of a school environment and in school where we're working on the learning and training pieces. So how do we address and meet the needs of our students with disabilities? That's the next slide.
I wanted to just quickly ask, I see you talk about the comprehensive district-wide safety plans, including school safety officers. Are those safety officers also receiving the additional training, or?
They should. That's in that April memo as to, that they should be getting that training. And again, to ensure that they do and get that training and that they're following that, hence the memorandum of agreement, making sure you're updating those contracts.
Awesome. Thank you.
Right. The last two are just basically the different things that you can do to support kids. Obviously, programming, reviewing whether they need specific program services, related services. I would say, also be mindful that we do have a variety of ways to support students, and that can include physical and environmental, such as using adaptive devices and accommodations. This will allow us to help and support our kids. Use of supplemental aids and services, considering your staffing, where the resources are, incorporating AT, looking at different universal design modes. How are we using our space? How are we using our, training and professional development to support our students and making sure that, there's good collaboration. For me, special ed is often as effective as gen ed in the sense that they really have to recognize that they are, hand in hand. It's not, oh, you have special education classification, you're over here. We have kids should be in the least restrictive. And so there's a lot of back and forth. And so we all, we need to think of them as our kids and not, special ed versus gen ed. We're one and the same. And so there should be a lot of collaboration and resources and sharing of that. And then the next slide, being aware of when you need to do an SBA and a BIP. If we have building level class wide or program-wide services and the student is not responding, that's when you need to be thinking FBA VIP. There's no instance where you don't do an FBA VIP. Well, we don't do that here at this program. No, you need to if that's necessary and appropriate. Yes, you may have a regular strategy and approach, but if that's not working, you may need to individualize it. It doesn't mean that you're going to throw your entire strategy out, but it may mean you have to look at the schedule of reinforcement, make it more frequently, make it more, tangible, make some other adjustments to it to meet the individual needs of this student. And then really looking at, our groundswell of support, which always starts with what are we doing for everyone? And then we add and supplement for students with disabilities as needed. And I always say it all comes back to, are we using the information in our data to inform our decisions? So it's not just enough to have things, but you need to review and assess the efficacy of those strategies and whether or not we are seeing changes in positive trends. If you are having more discipline and more removals, to me, that suggests that there may need to be review of our expectations, our requirements, and our commitment to, addressing proactively and, restoratively our practices as opposed to reactive and removal. The last couple of pages relate to the Workplace Violence Prevention Program and Protection Act. So I'm going to skip those because I said these are just directly from the frequently asked questions that were issued in June. So I will skip that, and we have a few minutes. So I will address any other questions that haven't been covered. And I'll turn to Helen or, oh my goodness, who else do we have here?
Alyssa.
Oh, I'm sorry, Alyssa, yes. And let me know if there's any other questions that you wanted to throw out to me.
I do have a couple, so give me
Okay.
just 1 second and I'll pull them up. One of them was about graduation. Is for graduation measures, is
Mhm.
there multiple options to show proficiency besides a Regents exam?
Well, it depends on different pathways, and for current, we have, a variety of different pathways through which students may satisfy outside of exclusively doing certain things, but there are also Regents requirements. That's what part of the redesign proposal is, that it may eliminate the Regents examination, but it still would require local or other assessment or measures. But the intent of the potential redesign is to allow individuals to demonstrate proficiency that are not exclusive to, what I call high stakes testing. They're looking for other more universal design modes. And again, I always think of it as it's sort of like an adaptation of special ed. We don't expect everyone will perform in the same way using the same measures. So what do we do in special ed? We accommodate, we provide, virtual and hands-on and alternative and, auditory-based instruction and ability to answer, in writing or in orally or in a project form. So those are some of the different ways that they're looking at exploring different means through which they can demonstrate knowledge and proficiency sufficient to demonstrate preparedness for post-school outcomes without exclusively relying upon, the Regents exam and others. And again, we have a lot of flexibility. We have our safety net and all of those things. That may also be altered. There was some concern that some of the changes might, make it more difficult. And, the intent and their goal is to make it more accessible for not just students with disabilities, but for, any learner who may be, having challenges with meeting those expectations. If they have the relevant competency and proficiency, looking to provide ways for them to demonstrate that instead of sort of relying upon that pen and paper requirement. And again, still subject to review. It does not apply now. I'm just giving you the heads up. And, keep in mind, same thing with the Dyslexia Task Force. There's still opportunities to, get your input in and make sure that, any questions or concerns are, being addressed or heard.
The next question is kind of long, but I'm going to do my best to condense it. So if a student has a diagnosis of dyslexia and they're receiving reading instruction by a provider who's trained in Orton Gillingham, but not certified, and the district does not have a teacher that's certified in that specific reading program,
Mhm.
does the parent have the opportunity to request a program review to ask for a different placement in a school that has a certified reading instructor?
So what you're getting into is methodology, and that's different from whether or not the person is using a research-based reading program and that it, documented, it's efficient, it's targeted and sequential services. To provide reading instruction, you have to be a certified special education teacher or, a reading specialist or a reading teacher, and you have to be qualified in the appropriate certification or licensure. You could also have, in some cases, districts have some of their speech language pathologists may also be involved in their reading and writing instruction based on their language-based background and experience. But there's no requirement that, district staff have to have, Orton Gillingham or the Wilson Academy and some of these other programs. They offer their own certification for their purposes, and they say, well, this ensures that you have someone who will implement with fidelity because they have, gone through all of our training and received a whole lot of our, supplemental, practices, and they, continue to pay to get those updates and supplements, and so therefore we certify and guarantee that, this is the quality that comes with it. Some district staff do have certain additional certifications or credentials, but from the requirement for the state, they have to be able to provide the reading instruction, and to do that, you need to be a certified teacher. And again, if you go to the dyslexia and dysgraphia and dyscalculia questions guide that I referenced from 2018, they actually sort of talk about that, this, sometimes reading instruction, maybe even through gen ed, because it's part of your RTI, it's part of your other interventions, and then other times it might be a special ed instruction. But going back to it, there's no mandate from a state level that it has to be someone who has this magical certification. That's based on that program's agency or who's selling that program. They give those certifications. What we need is to demonstrate that, they're providing research-based intervention using an appropriate, program, strategy, or approaches. And again, you have to be recognized that even those sort of standardized programs, they still have to have flexibility. If the student's not responding, you need to be able to adapt. So that's why, methodology is only going to be an issue if there's been evidence or there's, a basis or an argument, typically through a hearing, that the only approach that the student, receives is this. And that's one where methodology is not a mandate. It's not required to be part of the IEP, but I would say, systemic research-based reading instruction with, targeted intervention and focusing in on the relevant elements is.
And will districts be mandated to evaluate for dysgraphia, dyslexia, and dyscalculia, or is that just upon request?
That's going to, right now, we're still waiting for the outcome for the task force and their recommendations. As I said, this is part of the ongoing review. I would say that most districts are already reviewing and screening students for, suspected challenges in the areas of reading based on, phonemic awareness, phonics. They may be looking at their vocabulary, their comprehension. Most districts have their baseline assessments 2 or 3 times a year, plus their teachers who are providing that instruction may also be doing additional benchmarking and progress monitoring through both gen ed and then through, AIS, RTI, or MTSS. So that's part of it. There's a learning disability in the area of reading, writing, or spelling is a learning disability. The dyslexia, dysgraphia is more of the diagnoses that you can receive, but whether it's identified dyslexia, dysgraphia, or a learning disability, the response and the interventions are still, we need to teach the reading instruction, we need to remediate the areas of deficiency, and we need to ensure that the student is progressing through those targeted instructions and that they are, able to learn and to master those critical skills.
And then this is going back a little bit, talking about alternative instruction. It says, what exactly does alternative instruction look like? Is that just a couple hours over Zoom with the teacher, or what does it look like?
Right. What I explained was it's going to vary based on the student, the age, and relevant factors such as whether or not they're classified or not. If it's 2 to 3 hours of instruction, it's typically going to be, providing instruction and support for the student to keep up on their academic work. You know, instead of being in a class and delivered over the course of the day, it may be more targeted and more focused. And it varies based on the student. In certain special education students, they may need more breaks built in. It may be, they may have different teachers or tutors who are coming in. Every district has their own, setup and design, but it always still, for students with disabilities, has to be, reviewed and adapted to meet the needs of that particular student. And that's what the CSE includes in their discussion and recommendation for the IAES, the interim alternative education setting.
And this will be the last question. It says, do you know if the new graduation measures would apply retroactively? For example, if a student who was supposed to graduate last year but couldn't pass Regents, do they have to continually retake it until the new measures are adopted?
Well, let's say if you have a student who right now, if you had a student who sat for and challenged the Regents but did not pass, but had passed the class, if they have also participated in the remediation program and then make the second attempt, then the parent and student could apply for a superintendent's review and determination for that student to allow them to receive the credit recognition without having passed the Regents. They can do that for up to 2, and that is a current option that's available. There's also, compensatory options and other provisions, and I could go through that, but you could do a whole program on that. So there are current measures that provide avenues to get the credit, but the minimum requirements are, going to be ELA and math. And if those are the areas of challenge, if you have low pass, that could be 54, even down to 52, 53. But they still have to go through an appeals process. There's a lot of different options on that, but right now it doesn't apply retroactively. It might when they changed the superintendent determination process and gave us some new guidance on it. People were allowed to look at whether or not certain students who may have exited were still eligible to, receive that credit if they came back and were looking to apply, and many districts did. But whether or not the new adopted, guidance will apply retroactively will be something that'll be determined as a result of the plan and proposal to the Board of Regents. And if you think that that's something that, might be necessary to review, that might be something that you want to get comments from the state on.
Thank you so much, Tara. I'm going to stop the recording now.